Okay, good morning and welcome back to criminal procedure. Today we're looking at interrogation and ascertainment of bodily features. Now, when someone says interrogation, what comes to mind when you hear the word interrogation?
Being detained and possibly cross-questioned. And sorry, good morning,
Oh,
Ms.
good morning.
Pamji.
Yeah, but also the word interrogation brings to mind visuals and pictures of violence, of um, questioning, but questioning done in a forceful and even violent, physically violent manner. It's unfortunate. It's unfortunate, but that is the word that we have to use. But interrogation, what you would have picked up when we were looking at the various sections in the Act, particularly Section 26 and Section 27, interrogation very simply means, and as far as what the police are empowered to do, it means asking questions, the power to ask questions. Now, what we discussed in the slides and on the audio and what you've seen from the notes and the online text is that it's not because of what police investigation is and because of what is required. Investigation means to find out, to find things out. And the way to do that, one of the ways to do that is to ask questions. And so there's no piece of legislation which says, in a particular section in any kind of act, not even in the Criminal Procedure Act, which says police have the power to ask questions, full stop. That's not catered for because it's pretty much expected and accepted that that is part and parcel of what policing and police investigation is about. But what Section 26 and Section 27, read in conjunction with the various sections in the Constitution, Section 10, 12, 13, 35, etc., what Section 26 and 27 do is regulate or legislate for the manner in which, the way in which questions are asked and can be asked. Okay, and we'll talk about that as we move on. Okay. Yeah. Now, we also saw when we looked at the last set of slides last week, or was it the week before? I can't remember. But we saw that no one is obligated. There's no obligation on anyone to come forward with information, unless, of course, it deals with the crime of high treason. But whether you're a witness, whether you're an accomplice to a crime or witnessed a crime, or even the victim of crime, there's no obligation. In other words, it's not compulsory or a requirement that you go to the police and voluntarily, of your own accord, or even if it was compulsory, that you are forced to speak and forced to give that information. And although we can expect and accept that generally people would want to divulge information or want to give evidence to the police, make statements, etc., there are many factors, social and otherwise, as to why a person would not want to. In other words, they would be afraid to do so. And we spoke about things like witness protection and stuff in one of the earlier lectures. But there are several reasons why people just do not go forward to the police with their information. And that then also speaks to the reason why police are given the powers they have in terms of Section 26 and Section 27 of the Criminal Procedure Act. So Section 26 and 27 talk about gaining entry to premises in order to get access to a person that has information, whether that's a suspect or a witness. It all depends on where in the investigation process and where in the trial process we are. And we talk about things like, and this will come more clear to us when we look at things of search and seizure, the section on search and seizure, which also deals with this, the power to enter, gain entry onto premises in order to conduct an investigation. And for today's context, it's about gaining access to people that have information and getting the information from them. Secondly, when we look at search and seizure, getting access to physical evidence, the drugs, the stolen goods, whatever the case may be. Now, that being said, so Section 27. So, although you can only enter police officers conducting this sort of investigation or trying to get access to a person on a particular premises for questioning, can only do so with permission of the lawful occupier or owner, whoever is there, of the property. The question becomes, what happens? What happens if that permission is refused, that entry is refused? And that's where we have to cast our mind back to things like search warrants, or rather cast our mind forward, which we will talk about next week. Warrants for arrest, search warrants, those sorts of things, which give that kind of power. But when we were looking at arrests and arrest procedure, we also came to the understanding or the agreement that it is not always prudent, given the nature of the thing that is happening now and the factual scenario that is playing out. It may not always be prudent for a police officer to say, please wait here while I go and get a search warrant, or please wait here while I go and get an arrest warrant. And so that's where Section 27 comes in, and we talk about the ability or the power to use force to enter a particular premises. And the force in these circumstances, again, and we'll keep coming back to this, what is reasonable? What is reasonable force, right? And that is the power to break down a door, open a window, break a window, etc., and gain access that way. Now, there is one question. Now, you'll say, but what about the right to remain silent? Yes, everyone has the right to remain silent. You also have the right to protect you against self-incrimination. Okay. Now, but the police have the power to ask questions. Can any adverse inference be drawn? Number one, well, it depends on the circumstances. Certainly, if it's a court case or other thing, we'll talk about that when we get to the trial and we get to trial procedure. But can I refuse, as a suspect or as a witness, whatever, can I refuse to answer questions posed to me by the police? And the answer very simply is yes. Yes, you can. But there is one question that you must absolutely answer, because maybe right now you're not prepared to, willing to, or feeling safe enough to answer the questions of the police. And maybe the information you have is useful for the protection and pursuit of justice. And that will be something that will have to be argued in court towards gaining a subpoena to bring you to court to divulge what information you have. We're not talking about things like privilege and stuff at this point. But there's two questions that you must absolutely answer. And that question is, what is your name and what is your address? What do you think? And the repercussions or the consequences of failing to answer those questions could be a fine and or jail time. Why do you think that's important? Of all of the questions that the law could have forced you to answer, why choose those two?
I believe it's so they can locate you in case they need to ask more questions.
Fantastic, fantastic, exactly that. They need your name and they need your address, pretty much, or what, how can they contact you? Because if through investigation it turns out that this person will have or does actually have information, this person must be locatable. Because obviously it will be have to be argued in court whether or not this person can be compelled as a witness. If you guys have done evidence or you're doing evidence, yes?
Yes.
Okay,
Yes.
great. So, when can you be, in terms of the courts, when can the courts compel you to give testimony, right? And how do they treat you as a hostile witness, etc.? So we need then also, maybe as an aside, to talk about this right to remain silent. Number one. Second thing, regarding things you may have said in confidence to other people. Can those people be subpoenaed? and forced in court to divulge that sort of information or what you've said. How does confidentiality work then in this sort of context? You know about the doctor-patient privilege, confidentiality privilege? Yes? Okay. Do you know about confidentiality between you and your priest? Okay. And confidentiality between you and your lawyer? Okay. So can any of these individuals who, in a sense, guarantee that confidentiality, can they be subpoenaed and brought to court and forced to give testimony? What do you think?
Ms. B,
Yes, Ameshni.
I think that confidentiality has its limits. Like, for example, in psychology, there's confidentiality between the psychologist and the patient. But if I, as the patient, and you are the psychologist, if I tell you that I might harm myself or I might harm someone else, then that psychologist has the duty to go and inform officials and say that this person poses as a risk to herself or to the society at large. So I think that confidentiality has its limits and it's not absolute.
Okay, excellent. That's the perfect answer. And the court case that you're looking for that deals with that is Tarasoff versus the Regents of California. We can talk about that at another stage, and we'll talk about it when we get to bioethics in fourth year, if that's what you choose to do. But you're quite right. Confidentiality does have its limits. And you also see that from your study of the Sexual Offences and Related Matters Amendment Act, that there are certain types of offences that are reportable as between medical professions or anyone who becomes aware or has knowledge of the fact that there is underage sexual activity taking place, right? They are duty bound to report such behavior or report such actions, regardless of whether it's perceived as an abusive situation or not by the willing participants. The person, in this case, who fails to give that information or fails to make that report themselves may find that they are liable criminally for failing to report that. What about what you say to your priest in a confessional? Can a priest then be subpoenaed? So could he refuse to answer and this is what we're saying. We're saying that at this stage, when he's facing police questioning, the priest and even the medical professional, I suppose, could refuse to answer those questions. And the doctor could say, well, no, that's doctor-patient confidentiality. The priest could say, no, that's the confidentiality between my parishioner and myself. But with the information of the name and the address, the prosecutors or whichever party is making the argument could then make an application to court to say, no, this person should be subpoenaed. So even though they have not made a statement, have refused to make a statement to the police, this person should be subpoenaed and brought to court so that we can hear what they have to say. And look at your notes, listen to the audio, what we said about whether or not that will be done in open court or whether it will be done in sidebar or whether it will be done in chambers. It all depends on the circumstances and the sensitivity of the matter itself. But going back to that question, so as a priest, I'm refusing to answer these questions to the police, but I answer my name and address, obviously. When it comes to court, what then? Can a court order me to discuss or divulge what was said in the confessional? Anyone? And the answer is yes. The answer is yes. And we'll talk about that when we get to subpoenas and stuff later. And then the third question, the third type of privilege, which would interest you obviously more closely as practitioners or soon to be practitioners, is the attorney-client privilege. So your client may have said things to you or confessed or whatever to you. Can you, as the legal representative, then also be subpoenaed? Anyone?
I'm good. Just things are hectic. Oh. I'm still busy with
What do you think? So we know that doctors can be subpoenaed. We know that priests can be subpoenaed to give testimony in court. Can lawyers be subpoenaed? Go ahead, Umeshni.
I think so must be, because why should lawyers be exempt from that rule? If we are supposed to upload the law and we are supposed to be like these perfect individuals who aren't going to break the law and whatever, why should we be exempt? That's my opinion. I haven't gone through your side, so I may be incorrect. I'm going to be honest, I may be incorrect, but that's just my opinion. Why should we be exempt?
Well, we
from
are.
that?
We are.
We are?
And we are.
Oh my God.
And there's a very, 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 very good reason for that. It's part and parcel of procedural justice, and that. Okay, so Pooja's got a question. How would you represent someone if you have to divulge everything? Exactly. So we are upholding justice. Yes, that's what lawyers do. Well, we are part of a system that's meant to be friends of the court, friends of justice, and upholding justice. But as defense attorneys, we are also duty bound in the system of justice of providing our clients with legal representation, right? Legal representation. And the client that we are representing, part of that representation, whether you're for the state or for the defense, means that you must put forward a good case, a good case that you can substantiate, number one. Number two, but one that is not lies, right? In the face of what? Right? Just try and follow me here. What is the burden of proof for the state? What is it in a civil matter? What is it in a criminal matter? In a criminal matter, the state must prove beyond a reasonable doubt. Is that correct?
we would be able
Yes.
to prove.
In a criminal matter, right? Beyond a reasonable doubt. And what that means is that the burden of proof rests on the state.
Oh, me and you, we are covered. We are done.
Tandiswa, please unmute
That's
yourself.
fine. We don't have a problem.
Tandiswa. Right. So what was I saying? The burden of proof rests on the state. The state must prove that an accused person is guilty. It is not for the defense to prove that the accused is innocent. Are you following me? So, and we'll talk about this towards the end, what do you do when there's these sorts of conflicts where you've got a client that has confessed everything to you? What do you do? Well, you can withdraw is one option. The other one is you can counsel them to plead guilty and not to plead not guilty. However, if they still choose to plead not guilty in the face of all of the truth that they have told you, as a defense attorney, you would be causing a travesty if you allow your witness to take the stand and then actively tell lies. So I've said it a couple of times before that this burden of proof rests on the state. So it's for the state to prove all of the elements. Remember, your client still has the right to remain silent, so they can still decide not to offer testimony, not to stand up as accused number one and tell their version of events, however truthful or untruthful. It still will depend on whether or not the state has made a prima facie case. Now, in presenting a defense in this sort of scenario where we see where someone has actually told you everything, the attorney of record for the defense would not be ethical and therefore lawful for him to put forward a defense. But what they can do as far as the ability and the requirement that they defend their client as far as cross-examination, inconsistencies, and that thing is concerned, is to show whether or not and to test the prima facie-ness of the state case. We'll talk about that in a lot more detail, but it is very, very important that the attorney of record not be able to be subpoenaed and offer, because otherwise there will be no faith in the justice system. Okay, so Omeshni had her hand up, and then we'll go to Kaylin. Omeshni?
I forgot to put my hand down.
Oh, okay, no problem. Kaylin?
Good day, Ms. B. I wanted to ask a question with regards to capacity. So
Uh-huh.
now when you as a lawyer get subpoenaed, but it's something not in your legal capacity, what duty lies on you then?
Give me an example. What do you mean?
So if you
we were at dinner or in the park walking our dogs, and someone said something to me.
No, ma'am, maybe in a case where there's something like a conflict of interest.
No, you'll have to give
So
me.
you could be a friend and somehow along the line be a legal advocate for that person. And then when the state calls you or whoever calls you to stand, there's things that you know, but in that capacity, what lies on you then? Do you go out and tell the truth, or can you just avoid it all?
If what was said to you was in a context of an attorney-client relationship, you cannot be subpoenaed. But that would also have to be proved in court, that where it was said to me, when I witnessed it, I was there in my capacity as this person's lawyer.
Okay, thanks, ma'am. That gives me some clarity.
Okay, so that's the kind of thing. So that's what I was saying. Okay, so I'm just standing around, we're walking our dogs, you tell me something, or I give you legal advice, in a sense. Am I giving you legal advice as a lawyer, or am I just telling you stuff? And am I just listening to stuff? Or are you asking me for a legal opinion? So that then it's very difficult to say, well, this was in the context of a attorney-client communication, which is privileged, or was not. A good example is, do you know what was that case on the golf course? McCreary, Janssen van Vieren versus Kruger, right? That also had to do with doctor and doctor-patient client, and we can use it similarly as an example. So there was a dentist who then divulged all of this other information to other medical practitioners or other people that he would deemed or used as a defense would need to know this about this patient's HIV status. But the settings and the circumstances under which that divulsion was made was on a golf course, on a casual outing of friends. So those are the sorts of things that would come in. But we will talk about, we've gone way off topic. But just as an aside. All right, so yeah, so the police have the powers to question witnesses. They've got powers to question suspects and accused persons. So you can read about that. One of the other topical things that we need to discuss here is the ascertainment of bodily features. The ascertainment of bodily features basically means the taking of fingerprints, of photographs, footprints, handprints, DNA samples, pictures or photographs of tattoos, what else? DNA, blood samples. Glembula, you had your hand up?
No, ma'am, it was a mistake.
Okay, no problem. Right? So where this comes into question, or why we talk about it here when we're talking about interrogation as well as ascertainment of bodily features, because we said that the types of questions that you can ask and the type of question that you can be subpoenaed to answer, the Constitution protects you, and criminal law practice protects you again and gives you the right not to self-incriminate, so the right against self-incrimination. So when we talk about things like fingerprints, handprints, voice samples, photographs, and these are used as identification features in trials, in police lineups, whatever the case may be. In some of these instances, the accused persons have refused to give their DNA or have their DNA samples taken, fingerprints taken, or as you'll see from the Qaba and Gaka cases, to have physical evidence, to have bullets removed, saying that if you take this stuff from my body, it will be self-incrimination. What do you react? How do you feel about that? Are fingerprints, taking your fingerprints a violation of your right to self-incrimination? After all, without those fingerprints, they cannot possibly place you at the scene. Without taking the bullet medically out of your body or your leg where it's been lodged, without removing that bullet, they cannot match the bullet to the gun from which it was fired. Without taking your breathalyzer, your breath sample, they cannot say that, yes, you are definitively driving under the influence of alcohol. So let's start here. Is DNA evidence useful? Are fingerprints useful?
I think so, must be.
Yes.
Okay, we've watched enough CSI, haven't we? To see
Yeah,
the
yeah.
value of DNA evidence, right? Whether it's a civil matter and a matter for paternity, driving under the influence cases, murder cases, rape cases, whatever. But that is information, and inverted commas, we're saying information, that is evidence without which it cannot be definitively pinned on this accused person. It can be used to confirm a conviction, or it could be used to exonerate them. So how do we then reconcile? Let's start here. The courts have said that fingerprints, blood samples, semen analysis, etc., all of those things are not testimony. And that's what you need to look at when you look at the Fraser case, when you look at State versus Humor. That what makes this evidence, or what makes this retrieval, DNA otherwise, that is being used, not seen to be self-incriminating, is because when you talk about self-incriminating, it's about self-incriminating statements, self-incriminating testimony. And so the courts have reasoned that fingerprints, handprints, palm prints, footprints, voice samples, right? Handwriting even, there's a big question mark about handwriting, are not testimony. They are facets or features of what and who you are. And for that reason, taking them can be done, number one. Number two, they can be done forcefully, in other words, against your will, right? And they do not violate against the right to self-incrimination. What I do want you to look at, and I don't know if, I know I put the slides up late, so I don't know that you would have had an opportunity to look at the tutorial question, right? Let me just share the screen here. But maybe we can discuss it next week. This is the one that I need us to look at for next week. I know I put the slides up late, so I don't think you would have had the opportunity to look through this question carefully. But let's engage on this question next week, okay? And see what the courts have said. Now, so that's to come up. What I do want us to look at, though, also is this thing about police lineups. And you've been given slides with the rules for what's involved in police lineups. Now, this is taken from a movie, perhaps one of my all-time favorites, a movie called The Usual Suspects. The Usual Suspects. And I like to look at it or use it as instruction as to what and how police lineups should be conducted. First of all, why do you think police lineups or identification on these sort of parades are important or useful for the prosecution in court of crimes? Well, often in criminal trials, they are eyewitnesses. Eyewitnesses. And the eyewitness would, in some cases, have given a description or an identikit of the person they saw committing the offense, the person they saw fleeing the scene. And where it then becomes necessary for the police to have a suspect who will then become the accused and brought to court to face trial. And the witness would say, oh, it was a man, it was a young man about the age of 25, it was a white man, it was a black man, he had blonde hair, whatever, right? And it can, yes, Ameshni?
I don't know if sorry for interrupting you,
No
Steve, but
problem.
I just want to say that it allows the victim or the person who saw this, the perpetrator, allows him to safely identify the person because it's done through a one-way glass. So these accused people, they can't see the eyewitness or the victim. So it allows them to safely identify the person without being intimidated.
Yeah, but
by
why is that identification important?
the victim can identify the correct person because maybe the person who drew the identikit, maybe they misdrew some features or something, they missed something out and then they get the wrong person.
Yeah, so being able to point out, right? Point out is a way of saying to the system of justice that hold on, we do have the right suspect. We do have the right suspect. Okay. So the one of the pointings out will happen in an identity parade like this. It could even happen in a photographed type of a series of photographs in a photo album. Okay. And not only here, so even at the trial, one of the questions that categorically and formulaically get asked by the state to the eyewitnesses is this. And do you see that person in the courtroom here today? And that's where you see dramatically on TV, the witness points, yes, that is him there, okay? Because the defense on the other side can also bring as testament or as evidence, counter evidence to say that his client should not be found guilty, being that not once was my client identified as the person who committed the assault, who did the robbery. Right? Can you see where that. So where you've got this, you say, okay, there was a pointing out in the police line and the witness successfully did the same pointing out in the courtroom. There are some philosophical concerns or with that, because obviously if there is one person sitting in the accused dock, that person is probably the accused, right? And there's psychology behind that as well. But it's just formulaic in the sense that it sets it up that, look, at least we think we've got the right accused, unless the accused has some sort of alibi testimony. Omeshni, go ahead, you got your hand up again.
Sorry, I forgot to put it down. Sorry.
No problem. So
Sorry.
as much as we can use physical features, when you look at the rules, you'll see that there are requirements for these identity parades, as far as who can form them, who is on them, which police officers, whether it's the investigating officer or others that are required, what type of photographic evidence of the lineup themselves are taken, the composition of who is on the lineup, right? So let's say, for example, the witness says that she was robbed by a man who was wearing blue overalls. Now, that's all she remembers. She doesn't remember his face, but she remembers blue overalls. You'd expect that each of the individuals standing in this line would be wearing blue overalls, not just one person. So if I've got only one person in blue overalls, what does that say to this witness? That yes, absolutely, that is the person that you must choose as having being the person who you suspect of having assaulted you or robbed you or whatever the case may be, right? And there's rules, and you look at the rules as you go through about how witnesses mustn't be placed under pressure to feel that they absolutely have to identify the person on a lineup, and there will be multiple lineups, etc. And that's also to work towards the statistics on repeatable, whether if something is shown to you often enough, it'll stick in your mind, that logic. Yeah, so the same thing can be done for voice samples, voice identification parades. And again, you may listen to various recordings of voices, and again, similar voices. If you say you heard a man's voice, then you should hear a lot of male voices, not just one male voice amongst a whole lot of female voices. If you say the person spoke with an accent, that's the type of accent of voices that you ought to be hearing. All right. So that's all I have to say about that. So for next week, please, let's work on this. Sorry, I'm not going to put you under pressure now. I don't think you would have had ample opportunity to deal with this tutorial question, but please be prepared to deal with that next week. And the slides will go up sooner for the following lecture as well. All right, any questions moving forward? Any questions moving forward?
Was there a question?
Yes.
But it's not relating to our work.
Okay.
I'm not sure if you saw the article in yesterday's paper, and there's one again in today's paper about a shooting in Ghana.
This one at the party, the Halloween party.
Yes, an off-duty cop shot a man. He shot him dead.
Okay, talk to me about it.
I think the cop could raise a defense or private defense, because he's in the article. It says that the lady's husband stabbed him. He had a knife and he stabbed him. But then again, pardon?
No, but then again.
But then again, the cop shot this guy 7 times. So if it was private defense, if he raised that defense, so why would you shoot him 7 times and not just once so he could get away?
Okay, there's much to be said about that. If you're someone who's trained with using a weapon, and other police officers, even people in the army will tell you this, that if you're trained with using a weapon, you're trained to shoot in bursts of 3. So it's never just one shot. I think it's still bursts of 3. So pat, 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 and that will be, and you're conditioned to do it that way. it will, it's a thin argument, but, and then, about, what is that case? ED and rage and all of that. So without the facts, I don't know what's going to come forward in court.
An interesting one because like the cop they were intoxicated, and then the cop has like a mental illness. So I feel like it would be an interesting one to see what happens there.
Yeah, very, very interesting. There's a lot of, when you talk about exceptions to the rule in criminal law, right? Chrétien is an exception. ED is an exception. This would be the type of case that has all of the exceptions or
Yeah.
presenting themselves. It's very interesting to see what will happen. All right. Any other? No problem. Any other questions?
Miss Boundary, I have a question.
Go ahead. Go ahead.
Okay, I'm still on the notes of self-incriminating and how DNA is not a testimony. Yes.
Yes.
I need some clarity there.
Okay.
I'm not sure if I understand, but the whole concept of self-incrimination, how is it different from pleading guilty? I don't know.
Okay.
Or
Pleading
is it
guilty is
okay?
when you accept all of the elements. You accept that this is what I did and I'm not fighting it and I'm not gonna, I agree, I did it and I'm very sorry. So punish me as the law sees fit, right? That's
Okay.
pleading guilty. Self-incrimination is where you have no intention of pleading guilty. But the answer to the question that they're going to force you to answer will serve as evidence to incriminate you. So it's like an extracted, you don't want to give this information up. You have your right to remain silent and you do not want to give this particular information. That information without which the police will not, or the court will not be able to find you guilty, like a confession, right? Unless you confess, there's no way of knowing for sure, and that's when the trial would happen. So these things about self-incrimination, that's what those statements are. Now, DNA, your DNA is what it is. It is what you are. It cannot be altered, not yet anyway, it cannot be altered. And it's, where am I going with this? It's accepted as being a necessary tool in the investigation and prosecution of crimes, right?
Okay.
But it's not seen as, and look, it's a thinnish argument because think about it, without that DNA, they cannot.
Then how else would
Yeah,
they?
how else?
Yeah.
So look at how the courts have decided to reason that, look, here we're going to say that DNA isn't self-incriminating, and we're saying it's not self-incriminating because it's not a testimony.
Okay.
It's a thin argument in a sense, but it's one that we cling onto very tightly.
Mm.
Yeah.
Okay.
It's like, let's just accept that it is not. Because there have been similar arguments regarding handwriting, that handwriting is a learned thing. You can change your handwriting, but then say, oh, but voice samples is not a learned thing. But I know lots of people that are excellent at accents, at doing mimicry and that sort of thing. So how does that work?
Okay. Thank you.
You're welcome. All right, we good to go? Yeah, so work on that tutorial question and I will see you all next week. Thanks so much.